So welcome to the first Business Growth Club podcast. My name is Neil Foley, founder of the Business Growth Club, a club aimed squarely at helping micro and small business owners looking to grow. The purpose of these podcasts is to share the experience and knowledge of our members, thereby helping other business owners. In this particular podcast, we're looking at an often neglected area, namely how important it is to have legal contracts in place. We will share with you top tips and advice that will make you think and take action to protect yourselves. We're very fortunate this morning to have a lawyer with us who specialises in contract law and works with business owners here in Norfolk and East Anglia. So welcome to Ryan Cracknell, Managing Director of Cracknell Law here in Norwich, and thanks for agreeing to help and share your knowledge and experience.
Thanks, Neil. Thanks for having me.
Okay, let's get straight to the meat of the subject, Ryan. Why is it important for business owners to have legal contracts and agreements in place?
Okay, so I think the main point is certainty. You want to have a very clear position on what your rights and obligations are between your customers and suppliers, and ultimately you want to reduce your legal risk and exposure to them. So by having a clear set of terms and conditions or an agreement that is fit for purpose for that situation, or whatever the transaction is, it just ensures that each party knows where they stand. And if something goes wrong, you know what the position is without having to go through the court process, hopefully.
Hopefully. So that makes life easier, doesn't it? So when you say fit for purpose, are there different ones for contracts for sort of, if you're B2B or B2C, are there different terms of business that you would have?
Yes, potentially. So when you have a consumer relationship, there are different terms which need to be considered.
Okay.
There's a huge amount of consumer legislation which dictates how you have to deal with consumers. So, for example, cancellation rights, you have to offer consumers cancellation rights. Most of the time it's 14 days. It does depend slightly on what the goods or services you're providing are. There's some exceptions. Mm-hmm. But for businesses, you can basically agree whatever terms you like. There's not too many terms implied by law. So, basically it comes down to bargaining strength between the parties then, mm-hmm. Whereas consumers, it is more grounded in legislation and case law.
And presumably constantly changing legislation. I think May next year, isn't there? There's some quite big changes to the data protection rules.
So the new general data protection regulations are coming into force. It is an EU regulation, but will still have effect in UK even after Brexit. So, the law does change all the time. Laws like that you do have to be aware of, because data protection regulations will give the law teeth, and there'll be significant fines if you breach data protection laws. So it's good to be mindful of things, watch out for developments. Obviously with Brexit, we're not quite clear on in terms of how the law will change, but there's going to be a hell of a lot of EU laws which will need to be embodied in UK law somehow. Positions could change, which keeps things fun for me.
True. And this may sound like a silly question, Ryan, but in one way, what is the definition of a business? Because B2B sounds straightforward, but if you're dealing with somebody who's self-employed, or they're a partnership, is that the legal definition, or is there a legal definition?
Yeah. So I think if you're acting on behalf of a business, you'll be treated as being a business. So if you're in partnership, for example, it would meet the criteria. Mm-hmm. Self-employed, I think you'd have to review it on a case-by-case basis, potentially. You'd have to look at specific definitions within the consumer legislation. Can't think of them off the top of my head. But I think if, as I said, if you're generally acting on behalf of a business in the course of business, you'll be treated as a business rather than a consumer.
Right, okay. And is that true? I don't know if this is your area or not in terms of the data protection as well, because there's different rules, aren't there, regarding B2C and B2B. I wonder what the definitions are there.
Sorry, in terms of...
you're supposed to have the unsubscribe if you're doing email marketing to people. You've got to give them the option to unsubscribe.
Yeah.
I think that's less clear when you're a business. But again, this is the definition of a business that I think is quite interesting.
I think with data protection, I think it's across the board.
Oh, okay.
So it will apply basically what the Information Commission's Office, who are the authority in the UK for data protection, want to do is ensure that any personal data that's in the public domain is treated in a correct way. So even if you're acting as a consumer, if you obtain third-party email addresses, telephone numbers, the list goes on. But essentially, you would need to protect that information. One of the things that people sometimes fall foul of is they've got business information like a business email address or a business telephone number, even if it's in the public domain, because it can be linked to a living individual, it's still treated as personal data and needs to be treated in the same way.
Oh, crikey. So it'd be very easy to fall foul of that then, wouldn't it?
Yeah. Yeah. So it's important that you've got privacy policies in place which say how you manage personal data, and that just ensures that you're covered from a legal perspective. Just because obviously if you're investigated by the ICO, you can say, well, I have thought about how I manage personal data, and this is how I deal with it. I don't keep it longer than I need to, for example.
Yeah. And is that what you should have on your website then?
So ideally have a privacy policy on the website. It's particularly important if you've got an email us function or contact us function built into the website, because obviously then you'll be capturing a person's name, telephone number, email address, and any other sensitive information which is included within the email itself. So it's particularly important for that. You may want to have a separate privacy policy outside of the website, but again, it depends on how you use that data and how you obtain it as well.
Yeah. So you don't see that many websites with privacy policies on there, do you?
No. So this is something I see quite a lot. Ideally, each website should have terms of use, which dictates how users use the website. It ensures that you've got a breach contract claim against them, essentially. If they breach terms of your website, if they copy any content from it, ensures that you can say any information on the website is not guaranteed to be up to date or accurate at any given time, because obviously things can change. You don't want to be held responsible for having incorrect information. But also because of the borderless nature of the internet, it's good to say it's governed by English law. Well, it's aimed at people in England and Wales or whatever area you're in, just to give some kind of clarity as to what applies. Privacy policy, as I mentioned, is also key, and then a cookies policy. So again, this is an EU requirement through the cookies directive. Each website has to have a cookies policy. You ideally need to have consent from users on your website to agree to cookies. You see on a lot of sites to get the cookies pop up and I agree, and people just ignore it. I mean, there's discussions at the moment to do away with that, but you'll still need to have a cookies policy.
Crikey. So there's good work for you, isn't there? There's plenty around, Ryan, by the sound.
Yeah, basically. And we've tried to build a contracts package which includes your terms, conditions, and all your website policies into that.
Oh, so it's easy then.
Yeah, so we've identified that they're key documents for each business and tried to adapt our services to cover that on a cost-effective basis. So,
having been in the law for a while, Ryan, I mean, what are the mistakes that you see people making time and time again?
Okay, so yeah, I do see a lot of errors, and when it goes wrong, it can go really wrong. So I guess the first thing is the copy and paste predicament, as I like to call it. So people who have just obtained some terms offline, could be from a competitor's website, and they may change them slightly, but ultimately it's easy not to know what you're looking at. And I've seen several occasions where customers have copied terms and they're governed by completely different bodies of law, so US law, Canadian law, you name it. And the reality is, if there was ever an issue with those terms or in the commercial agreement, you would have to go to the US to enforce the terms, or you go into the UK courts and saying, well, it's governed by US law, can you apply US law? And they may well say, no, we won't. You should have got it right. So there's no need to create that kind of uncertainty. As I said, there's choice of law, but also jurisdiction. So you could say this agreement is governed by the exclusive jurisdiction of the courts of Florida. And your remedy then is only to be able to go over there. And even if you did do that, they'd probably say, well, all the services are being provided in England. Why are you doing it? So yeah, it's an easily avoided issue. Other things are where people copied contracts and not read through them properly. And they've left contact details in for other businesses. And again, it just looks unprofessional. If you're sending these terms to your clients and you've got a completely different business contact email, it just shows you haven't put the effort in, and could also have breach or issues in terms of that party approaching you if they find out they've copied your terms. Again, all easily avoidable. I've had a few other situations where it's gone really wrong as well. So you can pay quite significant amounts to have your terms done for you. But again, if you don't pay attention to what's being created for you, it could be completely wrong. So, for example, I had a client who paid a significant amount to have terms and conditions of business created for them, but they're completely focused on goods rather than services. So, again, having that clarity about what your rights and obligations are key, and they're completely skewed because this weren't applicable to the services being provided. In which case, if something does go wrong, how are you covered? And the other thing is that if you copy terms from somewhere else, then they may be a pro-customer agreement. You don't know. You also don't know how many times it's been copied from somewhere else. It could, so the original
mistakes can be compounded.
So I think it's easy to get your terms sorted or reviewed by someone, not necessarily me, but it's worth spending a little bit to get it right than spend a lot down the line trying to remedy the situation because you've got incorrect terms or inappropriate terms, and therefore you're exposed financially.
I guess it's one of the dilemmas, isn't it, for small business owners, especially when you're relatively new. Cash is always tight. Mm-hmm. I guess the old perception, maybe, of old school of lawyers is, an hourly rate and, can be a bottomless pit. Yeah. You mentioned you do fixed contracts in terms of fixed price, sort of a package, is it, so that people can come?
That's correct, yeah. So we call it a contract health check. So if you've got your own documents we've already created, we'll go through them, review them, update them, or we can create brand new documents. We also have a startup rate because we appreciate that for small businesses when they're starting up, they don't want to invest all of their cash into legal documents, and they shouldn't do. They should be focusing on building their own business. So we try to make our services more accessible to businesses, and ultimately we want to go on that journey with them to ensure that they're legally covered. And I've seen on a number of different occasions where I've worked with clients and they've spent £1,000 plus VAT with a quite large law firm. I think the top 100 UK law firm. And they gave them a 10-page non-disclosure agreement, which had some errors in it when I reviewed it, and just wasn't fit for purpose because the client just wanted to have a short document they could provide to a customer, had to have a confidential discussion, and they don't want to be having to say, read this 10-page document because it's just not practical to do so. My standard non-disclosure agreement is a page and a half, just to put it into context, and costs a fraction of the price. So it's not always the best route to go to the bigger firms, although majority of them will do a good job.
Yeah, I guess that's where because you specialise, it helps, doesn't it?
And you do find there's not a huge amount of commercial lawyers around.
No.
You do get people who dabble in certain areas of law, so they may be a person of all areas of law, as they say. You do run the risk that they're not an expert in that field. So, for example, I've had clients where they've had terms and conditions created, but they were a consumer-facing business and there was nothing about consumer terms, as I mentioned earlier. There's specific things you need to address, like cancellation rights, that just weren't addressed at all. So actually, those terms would fall foul of the legislation.
And bottom line, I guess that means you can't enforce, does it? If your terms of business are invalid.
They're open to be challenged by your customers, and therefore, it's going to be more difficult to enforce them. And the courts aren't going to be impressed if it gets to that point. So, I said it's worth getting someone who's specialised in commercial law, contract law, to look over them just to make sure they are fit for purpose. And what I try to do is spot the issues before they arise to avoid this prolonged process of, if you have a dispute, the worst thing is when you get a claim for them through the door. So having clarity on the terms is essential.
Yeah, it makes it easier. Yeah. And you're issuing, if, for instance, I've got terms of business on my website, people presumably have to accept the terms and conditions before they move on to actually complete the contract. Is that the process it needs? You can't do it after the event for it.
No. So it's about notice of the terms. So when you engage with a customer or supplier for a contract, particularly if it's an e-commerce site, for example, you do need to have a very clear notice that these terms will apply at the point when the contract is made. So for websites, that's why you see the tick here to accept these terms. Most people won't click on it to actually review the terms, but that's just to ensure that the customer is aware of the terms that are binding on them at that point. So when the transaction is affected, those are the terms that apply. And there's a number of different ways to incorporate your terms. You may want to reference your terms and conditions in quotations or proposals. For example, with the e-commerce websites, you may also want to send a copy of the terms with your email, with your confirmation email. So there's a number of ways to do it, but essentially you need to ensure the terms are sufficiently brought to the customer's attention at the point when the contract is made.
Okay. Now, and this is a layman's approach here. Now, I've heard it said that terms of business can't be unreasonable or unfair. Therefore, when I'm being issued terms of business, there's a bit of me that says, is there any point in me reading this? Because it's a bit like Apple, isn't it? When Apple send a new one, there's pages and pages. My guess is nobody reads it. Or if you say you don't accept it, then you're not going to do business with Apple, which is difficult. So is there a bit that says, actually, if they're all reasonable and fair, why not just sign them and accept them?
Okay, so for consumers, yes, you're kind of right. So there's the Unfair Contract Terms Act, which dictates that certain terms can't be unreasonable, particularly in relation to exclusions of liability. So with the likes of Apple, it is kind of a take it or leave it basis. You're not going to approach Apple and say, well, actually, I have issue with clause 13B. They're not going to entertain it. It's a take it or leave it approach. And if you want that service, you're going to have to agree to it. So from a consumer perspective, you're probably more covered, but you can't necessarily rely on the fact that all the terms are going to be great. They're not going to be in your favour at the end of the day. They're going to be in favour of the service provider. For businesses, it's a bit less regimented. So under English law, the courts and Parliament are quite happy for businesses to arrange and allocate risk between themselves. So you can agree pretty much any terms you like between yourselves. There's situations where Unfair Contract Terms Act will apply in certain situations. And there's certain provisions in law which you can't exclude. For example, you can't exclude liability for death and personal injury. And liability caps generally have to be reasonable. So typically it's 100% of the fees are 100 to 150% is generally seen as reasonable, but obviously case law changes from time to time. But yeah, essentially businesses can agree any terms between themselves. So they can be as unreasonable as they like in certain situations. And they'll be enforceable because the courts will see it that while the parties have got bargain strength respective to their own businesses and can have those discussions, if they decide to proceed, they're doing so on the basis that they're in the knowledge of what they're signing. So that's what's really important to know that, well, what terms am I signing up to? So again, it's worth having third-party agreements reviewed because ultimately, if you're using a supplier, the chances are their agreement's going to be completely in their favour. So
is that something that we would use a lawyer like yourself for? So if I had a terms of business from a supplier, and actually, because they're often written in quite a legalese terms, that actually something that is pinged over to you and you can cast your eye over it and say, actually, clause 3 sounds, are you sure about this, that and the other, and clarity?
Yeah, so obviously, reviewed thousands of contracts now over years of practicing, but because of that, I'm able to spot the issues quite quickly. So we've adapted our services to provide a really easy way of clients to be able to assess what the legal risks are in a contract. So it's our Shall I Sign contract. So it's Shall I Sign service, I should say, which basically we can adapt our level of input depending on what you need. So if you want a snapshot report, we can do that. So we'll just give you a bullet point list of key issues in the contract. If you want a full markup, we can do that. So we can basically go through and highlight all of the risks, all the things which aren't necessarily in favour. We can also amend the contract so it is more favourable to you. And also we can have that discussion with you to see what the key issues are for you. And we can also add comments into the document so you can send it back to the other side and say, well, this is the legal opinion we've sought. These are our comments if you want to proceed. We can also manage negotiations for clients as well. So we have a huge amount of experience in negotiating contracts. Just done a huge one with Walmart in the US And yeah, it's a prolonged process and lots of long nights, but it's really good when you get to an end result and the client's really happy because they've got a reasonable commercial position
Yep.
at the end of it where they're comfortable with the legal risk, particularly in somewhere like the US where you're more likely to be sued.
Yeah, absolutely. Now, I mean, again, this is something I see a lot in terms of invoices. I often see on invoices people have statements, that the goods belong to me and until the invoice is paid in full.
Yep.
How does that stand? I mean, is that a simple, straightforward thing to do or not?
Yeah, so it's basically a retention of title point. So if you've got a clause in your agreement which says that risk in the goods passes on delivery and title passes on payment, that's quite a standard position. Because you still own the goods whilst payment hasn't been received, worst case scenario obviously is you're not paid for those goods. You'd have the right then to go onto the client's premises to obtain those goods from them. And ultimately it reduces your exposure because you've got something physical that you can hold on to. You do need to reserve that right to do that in the agreement. And obviously, for consumers, it can be a bit more blurry as to what extent you can go onto consumers' premises and obtain your goods back from them. But for businesses, certainly you can say you have to keep the goods separate from your other products. You have to make them available to us.
Would this be in the terms of business? So in the terms of business to start with, and then you're reinforcing it by putting it on your invoices? Or
you could have it in your terms of business as long as in your invoices, ideally you should refer to they incorporate your terms of business.
Yeah.
You don't need to restate the terms each time.
Okay. But if I didn't have terms of business and I just put it on the invoice, does that work?
In terms of just having a retention title clause in the invoice? Yes, potentially. So the issue is obviously if you don't have a full set of terms, it's going to be a standalone clause and there's going to be slight ambiguity as to what terms apply to that. So what governing law applies? Is that deemed to be the entire agreement between the parties? For example, if when you gave them the invoice you said, oh, don't worry about this clause, it's not going to apply, what would be enforceable then? So ideally you should have it all set out in your terms and conditions of business to cover off those kind of points as well.
Okay. That's been fascinating, Ryan. Are there any other points you wanted to raise or issues that you were thinking of that actually you'd love people to know that, if there was one thing to take away, it would be this?
I think you just need to ensure that you're comfortable with your terms and conditions, that you know what's in them. You don't want to be in a situation where you're lying awake at night thinking, what have I signed up to? Am I exposed? Is the business going to go under because I haven't allocated my risk correctly? From my experience, it's very easy to get your terms and conditions up to scratch, and so they cover you effectively. And it's not as expensive as most people perceive. I think there is a perception that going to see a solicitor is going to cost an arm and a leg. We've tried to adapt our services so it's more accessible to do that, and we can kind of work in partnership with you to ensure you get a good end result with all of your contracts.
That makes sense. And in terms of your history then, Ryan, I know where you trained, but tell us a little bit about your academic history and your legal experience.
Yeah, so I went down the traditional solicitor route, so 7 years of training. So I did my law degree at the University of Kent, got a first class, then I stayed on there actually to do a master's in international commercial law, and again got a first, which was great. So it was a long slog to get to that point. I then went to London to do my legal practice course with the College of Law. Got distinction there. Then I did my 2-year training contract, so basically on the job solicitor training. And then after that, I did work in-house with a couple of companies whilst I was doing my training, and other firms as well, so based on a common arrangement, and kind of got to see the customer side of what they wanted, and I built that into my current services. And after I did my training, I went to Mills and Reeve and practiced there for several years. And basically I saw a gap in the market to provide a more cost-effective and accessible means of providing legal services. And there's not really too many businesses out in the market that do what I do, who just specialise in one area. basically tried to create a niche commercial law practice. And I should mention as well, so I'm currently classed as a non-practicing solicitor. So because I just practice non-contentious commercial law, it's a non-regulated sector. The plan is to convert my company into a law firm, essentially, by being regulated later this year. But basically just to provide the reassurance to customers that actually it is on the same grounding as all other firms, but we have full professional indemnity insurance and everything else.
Yeah, that's brilliant. Well, I appreciate you coming in, Ryan. It's been really interesting and fascinating. And thanks, everybody, for listening. If you want to know more, check out our website at thebusinessgrowthclub.net.